Mr. Smith.
May it please the court, my name is Mark Smith. I'm the state appellate defender. I'm here representing Jose Lopez, who was convicted of 2 charges following a jury trial, 1 charge of indecent exposure and 1 charge of stalking. A review of the record reveals that there isn't really too much to talk about with regard to the stalking charge. We concede that there was clearly sufficient evidence that he was stalking this person, even to the extent I think he wanted to talk to her even after the verdict was returned, if I recall the transcript. The issue, well, there are 2 issues raised in this case. One deals with a surcharge that was assessed against the stalking charge, and I think the brief probably adequately addresses that issue, and I don't really want to, I will talk about it if you have some questions about it, but I don't think it's terribly necessary to do that. The sole issue in this case is whether or not what Mr. Lopez did, that is sending 2 photographs of his penis, constitutes indecent exposure. And that's the sole issue in this case.
You know, the photographs on one end, the still photograph, and the being in the same room or the same space is the other extreme as I see it. But there's a lot of in-betweens. I mean, what happens if a video was sent? Or what happens if it was, what do they call it, FaceTiming? I don't know how to do that, but
well,
something like that. I mean, tell me in those situations whether if he did the same thing either through a real-time video or a older video, whether it could be indecent exposure.
Well, you know, in the Jorgensen case, which this court decided a while ago, that was a case in which some guy was walking around a store masturbating, as I recall, and the court in that particular case said that the issue of whether or not the security guards seeing him in the store constituted exposure was an issue that the court didn't have to deal with because it was not an issue that was raised in that case. And I think that the state has cited several cases in their brief, some of which I think address your question, and some of them are much further removed. Decker is the one that they talk about the most. It's a Minnesota case. I did take a look at Decker. It's on further review in Minnesota, and the briefs in the further review aren't due until next Monday, so we don't have too much information necessarily about what that is. But the issue that they're raising in that case is the Court of Appeals in Minnesota had to stretch the statute in Minnesota requires that this exposure be done in the presence of another person. And the Court of Appeals, the 3-judge panel of the Court of Appeals in Minnesota in that particular case sort of stretched the definition of in the presence of someone and found that in fact this exposure was in the presence of someone else because these 2 people had been instant messaging one another back and forth for some.
I agree with you. I'm not persuaded by that particular case. But what about the Missouri one where it seems to be more close to the majority opinion there, Baus or whatever that one is?
Well, that particular case, though, first of all, there's a sentence sort of toward the end of that case which distinguishes the charge in that case, which was attempted sexual misconduct with a child, from indecent exposure, and says this is not an indecent exposure case. And in that particular case, although it uses the term exposure, or the child being exposed, they talk about being exposed to alarming displays. And of course that was an attempted case because in fact the person that, as I recall, the person that they were conversing with, and this is in a chat room, I will say that I have gone to a chat room, but only to get information about how to fix my computer with a repair person on the other end. But that was, once again, more like we're talking with one another constantly. And quite frankly, if you take a look at the facts in that case, and if you take a look at the conversation that was taking place between the police officer and Mr. Bose or whatever his name is, I doubt that that would even be indecent exposure under our statute because of the tenor of the conversation that was going on. It's unlikely that Mr. Bose would have known that the other person would be offended by the exposure.
Counsel, as I look at this statute and try to understand what exposes means, it strikes me that the purpose of the provision is to discourage or prohibit the display of one's genitalia to somebody else. Why should it make a difference whether that exposure is in real time or done electronically, digitally, as it was in this case?
Well, first of all, because there are other statutes in Iowa that specifically talk about transmitting obscene photographs by phone. Okay?
But don't those other statutes that you're making reference to, I think that really involves with minors. I'm not sure that they really apply to the situation that we have here. I was kind of looking through there just to see, you're talking about 728 and the obscenity, and I just did a quick little review of that, but it all seemed to be more, again, in the idea of protecting children from the visual view of obscene materials. Am I wrong in that? Is there some other provision that I skipped over that would apply to our situation here?
No, there isn't. And in fact, with the exception, I think, of one section of 728, I think you're correct. It does deal with minors. But, and that
Maybe
section
these other
deals with
cases
the
kinda dealt with
public
that.
nudity with topless waitresses or whatever that section has to do with. But it seems to me that if the legislature thought that they needed a separate law to prohibit sending obscene photographs to minors, if the state's right, why wasn't the indecent exposure statute adequate? Because that would prohibit you from sending those things not only to minors, but to adults.
Only of yourself. Doesn't the other statute cover sending any obscene photograph, even of another person, right? Which wouldn't be covered by indecent exposure.
That's correct. That is correct. But the legislature knows how to outlaw, sending obscene photographs. They've done it with regard to minors.
Well,
If they intended that it should cover, the indecent exposure, they could have done it in that chapter. They didn't.
What do you make of the language in the next, or in the rest of that? It also prohibits committing a sex act in the presence of or view of a third person. So for that, they write in and express in the presence requirement. They didn't for the first provision. Does that mean it doesn't have to be in the presence of to expose your penis?
It's unclear, and that's a legislative drafting problem. To me, what that means is you can have indecent exposure if there are two people involved, but it takes three people if it's a sex act, because somebody else has to be in a position where they can see it. And so, I think that's what I would attribute that particular language to. It says, It's not indecent exposure to your partner if you are performing a sex act with them.
You know, this has been described as a visual assault crime, but I don't think you can assault somebody if you're not with them. I mean, to me, the classic example, as Justice Wiggins alluded to at the outset, would be somebody, you know, somebody who's there, who's physically present, the guy with the trench coat in the park. And then once you move away from that, where does it stop? Skype, you know, a drawing, would that work?
Well, first of all, I don't think you can move away from that. My position is you can't move away from that. That if you're going to regulate internet content, then you need to do that. But this statute doesn't do that. And there really isn't, you know, various gradations from, you know, there's somebody that can see me doing what I'm doing, or there's these other variations. There are no variations. Either somebody can see it or they can't. And if they can't, it's not indecent exposure. It may be another crime. You know, the legislature could say you can't send obscene photographs to anybody, but they didn't do that. They could have. And the statute seems unambiguous to me. What the legislature said is you have to expose yourself where other people can see it, and that did not happen.
Counsel, you just said the person has to see it. Well, Skinner did see it, right? And she saw exactly what Mr. Lopez intended for her to see, namely his genitals. What am I missing?
No, he didn't. She saw a photograph of his genitals, not his genitals. That's the difference. And even if you kind of, if you had reached the issue in Jorgensen, where apparently he was fairly unsuccessful at having his intended victim see what he was doing, but some security guards saw it on some video, I mean, that's much, much closer to him standing in the window and doing it when everybody walking by could see it. But this, you know, the cases that the state cites in their brief, and they're all, as far as I can tell, non-binding decisions in other courts, they are trying to stretch the in the presence language to somehow shoehorn in you're present with other people if you are talking to them over the internet, whether there's a camera there or not. And simply that's not what the law in Iowa says, and that's not what it means.
Does the word presence of or view of change this any? A view of, if you focus on those words. When you look at a picture, are you viewing it?
Well, yes, but you're not viewing the genitals, you're viewing the picture. And so, and that's, I think, the crux of it.
Back to the situation, what if it was a live video stream?
It's a much closer question. This one, clearly, there was no back and forth here. Skinner testified that these, I have to admit, I didn't count the number of text messages and things that went back and forth in this particular case. I know there were a lot of them. But she said after the no contact order was entered in the first part of April, she didn't respond to any of them. There was no conversation back and forth. So even Decker wouldn't reach the same conclusion.
But wouldn't you have to reach the same position if we accept your argument in the live video stream? I mean, what would the difference be that there's motion? If you're watching the live video stream, you're still seeing an image, not, in your view, the genitals, right?
That's correct.
So I mean, your answer to Mr. Justice Wiggins, I think, has to be that I still would win.
That's correct.
Yeah.
That's correct. The only time that I think there is sort of a broadcast sense of this is be standing in front of a window and people walking by can see. Then they're seeing what they're seeing, not a picture of what they think they're seeing. Thank you.
Thank you as well, Mr. Smith. Mr. Howe.
Thank you, Your Honor. May it please the court, counsel. When interpreting statutes and rendering decisions, this court strives to avoid absurd results. The state would ask that it do so again and affirm Mr. Lopez's convictions for indecent exposure and his sentence for stalking. With your permission, I'd like to begin with actually the second portion of the argument, which would be whether or not Lathrop's presumption is applicable in this case. It's the state's position that it is not. When Lathrop was drafted, it acknowledged that exceptions were, for example, the Coles case, where we had an implicit acknowledgement that the defendant's conduct straddled both sides of the adoption of a new sanction. That presumption, or I should say, there are no such circumstances in this case that would leave this court questioning whether or not Mr. Lopez's stalking conduct occurred exclusively before the adoption of the statute. His arrest at her residence on August 3rd, I think, is more than sufficient to resolve any question in that area. Accordingly, the state believes that there is no ex post facto application of Iowa Code Chapter 911 2B's $100 surcharge, and his sentence should be affirmed.
That all sounds logical, but how do we know what the jury found?
Well, Your Honor, Lathrop was adopting the general verdict presumption from cases like Hogreff and Pilcher, where there was literally a deficient theory of prosecution. That's not a problem here. We know exactly that Mr. Lopez was stalking Ms. Skinner, and the fact that we have, frankly, not even defense counsel contested the veracity of the state's evidence that he had sent these text messages and that he was arrested outside her house. There's no concern. It falls outside the circumstances anticipated in Lathrop.
But we don't know what time the jury convicted him of stalking, whether it's before or after the enactment of the statute.
I would respectfully disagree with that, Your Honor. I understand the general proposition that we don't know which portions of the state's evidence the jury did or did not accept, but there's overwhelming evidence of Mr. Lopez's guilt in this instance. It makes no sense. It would be an absurd result to reverse in this instance.
It might be a better practice for the state to ask what date are you convicting on, so that if they wanted to do this surcharge, we'd be clear in the evidence.
That's a fair point.
That's the absurd thing for the state not asking for it.
I would acknowledge that a special interrogatory was a thing the state could have requested, but the evidence in this case was overwhelming. Mr. Lopez's own counsel acknowledged his conduct. I don't see any ex post facto implications from applying 911 2B. I would also note that counsel was not ineffective for failing to challenge the state's evidence of his crime of indecent exposure. The current version of the indecent exposure statute has been around since 1977, and no such claim akin to this has been raised since then. I think it's demonstrative of the fact that the Iowa legislature drafted an unambiguous statute that sending a photograph or a video of one's genitals is in fact the same as exposing their genitals to that
Well,
person.
what about, let's use Justice Waterman's hypothetical. Suppose instead of texting a photograph, he had drawn a picture of his penis and texted that to the victim. Is that covered? Is that indecent exposure?
I appreciate the question. The answer is no, that would not be indecent exposure.
And why not?
So think about it from a photograph example in which we have light, not to be overly philosophical, but light is reflecting off of the defendant's genitals into an aperture that captures the moment and then sends it or preserves it for subsequent viewing. A drawing is sufficiently distinct from that. A drawing is an artist's representation. Theoretically, it would fall outside the obscenity statute if it did not.
So what happens if he sends a photograph of someone else's genitals and say they're mine?
Well, Your Honor, he
indecent
would
exposure?
absolutely have a defense to that because it requires the defendant to send an image of his own genitals. I agree.
Counsel, you've identified that this statute is 35 or 6 years old, and we certainly have to assume that the legislature could not have intended for the statute to apply to a form of technology that was not yet in existence, right?
I would agree. If you don't mind, I would note that in 1977, the idea that someone could transmit or broadcast an image of their penis was not impossible. It was possible via television networks. It was impossible via film and photograph. I think the legislature had remarkable foresight in acknowledging that there are other means other than in-person display. And in
Okay,
fact, it did so. Oh, I'm sorry.
Is there any indication the legislature intended it to apply outside of this in-person display?
I believe so. I believe that the legislature's creation of a separate crime of committing a sex act in the presence of or view of a third person and explicitly requiring that does remove the first example of exhibiting one's genitals, makes it a separate crime. And I think we can resolve any concerns we have over the potential reach of this through the center requirements. Not only does the exposure have to be of the individual's genitals, it has to be for the purposes of their arousal or their subject's arousal, and it needs to be done in a context where they know or reasonably should know it would be offensive.
Instead of I mean, I've been thinking about your kind of metaphysical line that you're drawing.
Certainly.
Instead of that, what if we drew the line and used maybe imported some concepts from copyright law where once something's in a fixed medium, then it's no longer the thing, it's the medium that exists, and at that point it's not indecent exposure. What about that?
Sure.
Drawing the line there, since it's a photograph of a picture or an image that was taken in the past and then sent along, that's not indecent exposure.
Well, I would respectfully disagree with that. The reason being that for example, the definition of the word expose includes exhibit, display, excuse me. And those presume, of course, that there is a viewer, but they don't require a means or a modes of transmission. The legislature knew how to require an in-presence or in-person. I understand that you're suggesting that, a fixed medium is different, but for the purposes of avoiding what the statute intended to, which is the visual offense and affront of seeing someone's genitals unsolicited, I think that we would be acting contrary to the legislature's intent, especially when they did not indicate a mode that they would find it to be indecent exposure.
But isn't it far more offensive or concerning if the person is physically with you, in front of you, and they expose themselves, and then the victim is worried that what can happen? He's right here. As opposed to a text that's at a different time, she could ignore or delete. There's no physical threat related to it at that moment.
I understand the question, but I would note that the legislature doesn't deal in terms of offense. It asks whether or not the individual exhibiting their genitals knows or should know it would be reasonable, or knows or reasonably should know it would be offensive. And there's no question, either your in-person suggestion or Ms. Skinner seeing Mr. Lopez's genitals was offended. It doesn't deal in more offensive or less offensive. It is just offensive, and it was.
The Missouri dissent in that Bowles case suggests that the government's interpretation in that case, in effect, added the words, display your private parts or a photograph. Are you asking us to read in or a photo or video?
No, Your Honor. I believe genitals would include photograph. I'm not asking for an additional term. I think there is no logical distinction in the statute between a video or a photograph and just an in-person demonstration of one's genitals.
So in the state's view, seeing a photograph is the same thing as being present to see the real thing.
And the reason I say this is that would create some sort of absurd outcome where if someone was your historical flasher with the trench coat in public and they had an iPad facing with a reverse camera, that would not be indecent exposure, and that defies credulity. It's absurd.
I mean, I'm still thinking maybe you could draw the line between the real-time transmission and sending along a photograph that was taken in the past.
I struggle-
And I'm not. I'm just trying to arrive at a fair interpretation of these words. Mr. Lopez's conduct in this case is not sympathetic. I think we would agree, but we need to apply the statute as it's given.
Certainly. But I would also note that I can understand the compromised nature of allowing a real-time video rather than a still photograph. But the problem with that is twofold. One, there's no presence requirement in Iowa's code for this version of the offense. And two, literally that video would be nothing but a collection of stills run in time. Again, we'd get right back to our core problem. The photograph or the video containing micro photographs is no different than the display of genitalia. The offense it causes, the affront, the alarm, they're all roughly the same, Your Honor. Not roughly, they are the same. Again, I would note that this is all in the context of whether or not Mr. Lopez's counsel was constitutionally deficient for not anticipating this argument on a statute that's been around since 1977. I think, especially when we look at the second part of his argument, the jury instructions, where the jury instructions not only exactly matched the model jury instructions, but matched the statute exactly, and the jury found no question that Mr. Lopez's conduct satisfied. I would also note that there is some indication in the case that defense counsel's approach to this particular count in this prosecution may have been strategic. Relatively little defense was put up against the indecent exposure count, and I would note that it seemed as if, in my reading of the closing argument, the defense counsel was much more preoccupied with avoiding a conviction on stalking. It's not an unreasonable trial strategy to attempt to essentially admit and confess guilt on one count in order to avoid another conviction. For the foregoing reasons, the state would request that this court find that Mr. Lopez's counsel was not ineffective and affirm his sentence for stalking. Thank you.
Thank you as well, Mr. Howe. Mr. Smith.
First of all, I think there's very little strategy in confessing to something that's not a crime. And the attorney should have been smart enough to know that this was not a crime. There's no case in Iowa that says it's a crime. Back to, I think, Justice Mansfield's question about sort of something fixed in time and something current. In the Decker case that's cited by the state, they cite a case called Brooker versus Virginia. In that particular case, first of all, they have a specific statute which makes it a crime to use a communication system to entice a child to commit another crime. But even in there where they're talking, and in that particular case, that was as I recall, I think that's a webcam case. The court points out in there that the exposure that occurred in that particular case was a crime because it was liable to be seen at the time of the exhibition, not liable to be seen some other time. And I do understand that movies are made up of small little increments of pictures, but they look like they're all occurring right now. This isn't that. This is two photographs or one photograph sent twice. It's a little unclear to me whether it's actually two photographs or just one photograph that was sent twice in rapid succession, it appears. But that's not what this case is intended for. You know, you talk about it being a visual assault crime. It's not possible to assault someone unless you're in the same place. You know, if I send a text message to somebody that says, you know, the next time I see you, I'm going to beat you up, that's not an assault because I don't have the present ability to carry it out. And in this particular case, there could be no exposure because these people were separated in time and space, and it just simply is not covered under the statute. Actually, I think the statute's been in effect for about 40 years, in 1977 or so. And the legislature has not seemed to change it. They do understand that there are some crimes that you can commit using electronic means. This isn't one of them. This isn't one they decided to change. We request that the court set aside the conviction for the indecent exposure. Thank you.
Thank you as well, Mr. Smith. The case of State versus Lopez has now been submitted, and the bailiff may adjourn.
The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.